Ladies and gentlemen, I would like to warmly welcome you to today's webinar, which is organized jointly by the Marangopoulos Foundation for Human Rights and the Mediterranean Institute of Gender Studies. We all know that gender-based violence is still one of the biggest challenges of our societies. There are various initiatives aiming to address this challenge, one of them being the recent proposal for an EU directive to combat violence against women and domestic violence. So on the occasion of this draft directive, today's online discussion will address global and regional tools to prevent and combat all forms of violence against women. Our panelists will exchange on how legal standards in the field of violence against women can provide for sustainable solutions and at the same time for harmonized responses. We will look into the successes of each organization's work in combating gender-based violence, but also we will discuss on the importance of and the need for cross-fertilization among relevant standards. So in this regard, we could even identify opportunities that arise from the EU directive. We could deliver food for thought on possible amendments, or even identify ways to enhance harmonized solutions, in other ways to enhance an integrated approach. Our panelists are well-known experts, and I don't think that they need an introduction. However, let me briefly welcome them. Ms. Iris Luarasi is the chair of GREVIO, that is the group of experts on action against violence against women and domestic violence. GREVIO is the independent expert body that is responsible for monitoring the implementation of the Istanbul Convention by state parties. And I have the pleasure to be member and second vice chair of this group and to work under the leadership of Iris. In addition, Iris has an extensive experience as a civil society leader in the fields of gender issues and women's rights. I would like also to welcome Ms. Genoveva Tishova, who is member of the UN Committee on the Elimination of Discrimination Against Women, the CEDAW, and also chair of the Working Group on Gender-Based Violence Against Women. Ms. Tishova has an extensive experience in legal reforms and strategic litigations in the field of violence against women. May I continue with Ms. Susanna Pavlou, who is the director of MIGS, which is co-organizing today's webinar. Susanna has over 18 years of experience in research, policy development, and monitoring, especially with regard to gender equality and violence against women. Susanna has served as a senior researcher on a number of projects, and today is taking part in our discussions also in her capacity as vice president of the WAVE network. Ms. Eniko Pap is a legal expert at NANE Women's Rights Association, which is based in Hungary. This association has close to 30 years of experience in working to eliminate violence against women with a range of activities. So the expertise of Ms. Pap relates to the application and the implementation of international norms on women's rights with focus on the state responses. She also serves as a secretary of the Hungarian Women's Lobby. Allow me now to hand over the floor to the co-organizers, to Susanna Pavlou for her welcoming address. Please, Susanna.
Thank you very much. And I want to very warmly thank the Marangopoulos Foundation for Human Rights, and in particular, Maria-Andriani Kostopoulou for inviting us to co-host this webinar. I met Andriani very recently during her visit to Cyprus, and she kept her promise that we would work together, particularly in the context of this new proposal for an EU directive on violence against women and domestic violence. So thank you very much for inviting me and for inviting us to co-organize this webinar. So just very few words before we start. This directive is an essential first step in the direction of a harmonized approach to violence against women and girls in the EU. This has been a key demand of women's organization and women's specialist services, and especially necessary for member states that have not ratified the Istanbul Convention. Of course, this is something that I hope that we will be discussing during this webinar of how we can, as Andriani mentioned, how we can join forces and cross-fertilize so that we don't leave this groundbreaking legal instrument, which is the Istanbul Convention, behind in these efforts. By proposing definitions of 5 forms of violence and establishing minimum standards for prevention, prosecution, protection, and integrated policies to fight violence against women and girls, this directive could be a very important instrument which can greatly improve national legal systems across member states in the EU. Despite this, we have, as women's organizations across the European Union, we have a number of concerns in relation to the proposal, and I'm looking forward to sharing these concerns and discussing these concerns with you, and also hearing from my fellow panelists and to hear their perspectives as well. So I look forward to a very productive webinar, and Andriani, I give you the floor.
Thank you very much. Let me just explain the format of our discussion. In view of questions and comments that we have already received, and we are grateful for this, we decided to opt for a more dynamic and more interactive dialogue instead of separate presentations. So we will proceed with 3 rounds of questions addressed to our panelists. And afterwards, if time permits, we will also address any questions or comments coming from the attendees. So dear attendees, you are encouraged, welcome, to use either the chat or the Q&A option to share your thoughts and comments. So dear ladies, let's get to work. Let's start with the first round of questions. And I would like to begin with Iris. So Iris, the Istanbul Convention has a prompt change in law also and in policy in Europe for over 10 years. And now many people call it the gold standard. I would like to ask you, what makes the Istanbul Convention so unique?
The Istanbul Convention is very unique because it is the legally binding convention, and that's why compared with other conventions that are related to women's rights and human rights in general, that's the only convention that is legally binding. So it makes for the countries that ratify the convention a legal obligation to be implemented. On the other side, I would say that the drafters of the convention, they have been absolutely very smart, and we all in Grevio have been very proud to have some of the drafters in the current Grevio, in the previous Grevio, 2 former presidents, the first Vice President Rosa Logar, and the Executive Secretary Johanna Neles. They all have been among the drafters of the convention. So they have seen that in a very detailed things. It is composed in 7 chapters, and one of the things that it makes very interesting and very unique, it's also the migrants and the asylum seeker when they are women. So that's why I'm saying that one of the things that makes the Istanbul Convention very unique, it's this fact of going in every detail of protecting women's rights and victims of domestic violence, but also because of the fact that it is legally binding.
Yes, thank you. Thank you indeed. And of course, having a monitoring body to overview its implementation could also be considered as an added value. And the same goes, I would say, with regards to the CEDAW Convention. And now I would like to turn to Genoveva. The CEDAW committee has also fostered changes and improvements, and I would like us to focus to the example of the status and the treatment of women victims and survivors of violence against women. And I would like to ask you, Genoveva, how does the CEDAW committee address the question of providing protection and ensuring the victim's dignity? Could you please unmute your micro? We cannot hear you. You're still muted, Genoveva. I don't know if you can hear us. Yes.
Can you hear me now?
Now it's fine. Yes, please.
Oh, okay. Thank you very much. So good afternoon, and thank you very much to the Marangopoulos Foundation for Human Rights and the Mediterranean Institute of Gender Studies for this kind invitation. And thank you very much for inviting me among friends and colleagues as such eminent experts in the field of women's rights and gender-based violence, with whom we are part of the also women's movement in the region. I would like to focus really on the role of the CEDAW Convention, of the work of the CEDAW Committee in relation to the position and treatment of victim survivors of violence against women. First of all, as we all know, to say also about the CEDAW Convention that it is the main source of universal standards concerning women's rights and women's dignity, autonomy and economic independence and empowerment in all fields, and including it very important through clear obligation for state parties to adopt temporary special measures in order to achieve substantive equality where needed and combat gender stereotypes. So the convention also has very strong focus on the elimination and the protection against violence against women globally. So we are part with the review committee and with other mechanisms at international level of a platform that will maybe speak further in the discussion on the gender equality mechanism concerning violence against women at global level, unifying these actually institutions at global level. I would like to say that through the General Recommendation 35 on gender-based violence of the committee, there is clear recognition of the protection against gender-based violence against women as a principle of international customary law. Very important because it has been used by the state. There is compliance by the state with obligations under CEDAW and other international documents and wealth of legislation concerning protection against violence against women. So the committee has been systematically addressing the position and treatment of victim survivors of violence against women in the criminal civil proceedings and insisting on enhanced protection by the state parties for ensuring victims' safety and dignity. And this is also under the state obligations and obligations on due diligence under the convention and other international standards. So we follow that as a committee. And through our main method of work, the dialogues with the state parties, we make recommendations under Article 4 to adopt appropriate legislation, for example, but also I would say we recommend where there is necessity for that also the ratification of the Istanbul Convention by the states which are not still part of it, and to ensure implementation of legislation and policy to guarantee access to justice for women without gender stereotyping by the judiciary, law enforcement, and other institutions, but also to modify and repeal discriminatory laws and practices. Also, we follow the application of these principles and these obligations of the state through also the application of the very important Article 5 on gender stereotyping and prohibition of gender-based violence, which really corresponds to the specific article against gender stereotyping in the Istanbul Convention, and our Article 15, equality before the law. Here also, when we monitor the implementation by the state, the general recommendation 33 on access to justice for women and 35, as I mentioned, on gender-based violence are applicable. And also the committee addresses this important issue through its views and recommendations under the communication procedure under the optional protocol. I would like to say that over half of the cases decided communications decided with views under the optional protocol concern gender-based violence against women, and also the majority of the inquiries, the other procedure under the optional protocol, are also related to gender-based violence against women. Just to give some examples of recommendations and principles for the treatment of women victims during the proceedings, just some examples from the practice, as I said. The dialogues and recommendations to the states and the recommendations in the views under the optional protocol, like strengthening the judicial system, including through additional financial, technical, and specialized human resources. We focus very much on that, with the view to handling cases in a timely, gender-sensitive, specific issue, I think that we'll discuss further, a non-discriminatory manner, in order to ensure that gender-based violence against women is prosecuted promptly and effectively, investigated and prosecuted. And also very important role of the committee to monitor the level of gender stereotyping by the state institutions themselves. So we recommend to ensure that women are protected against discrimination committed by the judiciary and the public authorities. And another issue I think that will be discussed during this this debate, online debate, is one of the obstacles for women, and one of the central element for intimidation of women in the situation with respect to their children. So what the committee recommends clearly, I would like to remind, the rights or claims of perpetrators or alleged perpetrators during and after judicial proceedings, including with respect to property, privacy, child custody, access, contact, and visitation, should be determined in the light of women's and children's human rights to life and physical, sexual, and psychological integrity. In several cases, it was recommended, and in general recommendation 35. Just to add some other principles in order for the discussion, I think it will be important. And in cases of domestic violence against women and children, there is need for addressing specifically credibility and weight to be given to women's voices, arguments, and testimony. And another recommendation related to that is because there is difficulty of proving any kind of illegal act against women and their children if we do not apply these principles of equity and actually giving weight to the testimonies of women and their children. And so the committee systematically emphasizing that the perpetrator's rights cannot supersede women's human rights to life and to physical and mental integrity. Also to give priority to criminal prosecution over reconciliation or mediation in the criminal proceedings and in cases of domestic violence. So this is recommendations also to Lithuania. Also in the region, recommendations that we also made is provide victims of gender-based violence with safe and prompt access to justice, including free legal aid where necessary, and also in order to ensure that they have access to effective and sufficient remedies and rehabilitation, in line also with general recommendation 33 on access to justice. It's important because it's also within the scope of the draft directive we will be discussing, ensuring the assistance and also the sufficient remedies and rehabilitation. Also at the level of our discussion, I think it will be mentioned here. Also, specifically the right of migrant women, as here is said, is also to have effective access to justice for them, to have access to other services and translation services, and also more, let's say, communication issues, but very important in the digital world. I think we recommend to states to intensify efforts to address the physical and economic barriers to access to justice for women and girls, but also investing in modern information and communication technologies and accessibility in order to enhance awareness among women. And strengthen through the trainings that also I think the Istanbul Convention largely provides, and also in the recommendations to the state and monitoring process there. So the capacity building of women's rights and gender equality would be very important for the judiciary. And finally, would like to say very important, the CEDAW created a body also of case law concerning attacking gender stereotypes in the judicial proceedings, specifically concerning sexual violence and rape. So it is addressed in Karen Vertido case, as we know, versus Philippines, LPB case versus Philippines, the VPP case versus Bulgaria. I think very important body of recommendations to eliminate the myths and the beliefs how, let's say, a dignified victim should behave and what is violence against women and what kind of level of severity should be in order to have violence against women. So attacking gender stereotyping is a central role for the committee when actually considering the state reports, but also in the communications. Thank you very much. Can you hear me?
Yes, yes, very well. Thank you so much for this impressive
point for discussion. Yes.
Yeah, absolutely. You raised many issues. You touched upon many dimensions. Also, you referred to key provisions, and we saw also the interaction with other standards, and of course with the Istanbul Convention. Among other things, you touched upon recent trends, and that was also very important and useful. We will come back to all of this during our discussions. So far we received some important input on the work of Grevio and on the work of CEDAW committee in protecting women victims of violence. But let us now move to and see the perspective of the draft EU directive. And let's focus on the important topic of specialized assistance. We know that there is already a directive called Victims' Rights Directive. And I would like to ask Susanna, what do you think that could be the added value of a directive on violence against women in relation to the Victims' Rights Directive, and more specifically, as far as specialized assistance to victims of violence against women and to victims of domestic violence is concerned? How would you see the connection and the interaction among these two instruments?
Yes, thank you for the question. Our position has always been that any initiative, policy, legislation needs to build on the decades-long feminist and gender-responsive expertise of women's specialist services. In our perspective, the directive falls short of this, and I will be a little bit more specific. So the directive, very similar actually to the Victims' Rights Directive, but I will get to that, focuses on the main implementers, the member states and their competent authorities, to increase, as the directive states, to increase reporting rates and integrate victims into the criminal justice system by ensuring that the competent authorities refer victims to specialists and or general services before, during, and after criminal proceedings. I will not touch upon at this stage with this question the focus on criminal proceedings and on law enforcement and on the criminal justice system. But this focus on competent authorities and referral to indicates that victims' access to shelter and other specialist services are subject to the referral of the victim by state authorities. And in this respect, our concern is that, and this is very similar to what is stated in the Victims' Rights Directive. So our concern is that mandatory referrals might prevent some women, specifically women from disadvantaged, minoritized, and marginalized communities, from coming forward to seek help due to lack of trust in the authorities. At the same time, mandatory referrals will stand in the way of self-referrals by victims themselves. And this is something that Grevio has emphasized in its reports to state parties. So from our perspective, victims or survivors should not be pushed to engage with law enforcement or the criminal justice system if they are not ready to do so. Likewise, specialist service provision should not be made dependent on victims' engagement with criminal procedures, nor be seen as only necessary, nor should these services be seen as only necessary before, during, and shortly after such procedures. So the recognition of the role of women's organizations and women's specialist services in the text of the directive is weak at best, and in our perspective deviates from the standards defined by the Istanbul Convention, which expressly includes civil society as active implementers, recognizing the crucial role of women's organizations and considering their specific, in considering the specific experiences of women and girls. So this focus on state intervention and law enforcement, in our view, does not take into account the complexity of women and children's pathways out of violence. And these are the complexities that women's specialist services, through decades of experience and expertise, are best placed to understand and respond to. Despite this, the proposal, particularly the provisions of Chapter 4, which point to specialist services and support services, in our view, has a limited a view of support services, as does Victims' Rights Directive, which are general and gender neutral services. This is how we feel that the Victims' Rights Directive, from our perspective, has failed to respond to the specific experiences of women and girls, specifically because it promotes a general and gender neutral services, which we do not agree with. We disagree with this limited view of services. And it seems to us, very similarly to the Victims' Rights Directive, that it's exclusively tailored to victims of crime and not on the much broader and complex aspects of women and children's experience of violence against women in domestic violence situations. One example is the focus on the one-stop shop approach, which some women's specialist services have been critical of because it doesn't consider the complexity and the modalities on the steps that only women can decide need to be taken in her pathway out of violence according to her own place, according to her own pace. And this model, focusing on this one model, depending on how it can manifest itself. But in our experience, this puts a woman who is looking to leave a violent situation, being thrown into a vortex, if you like, of interventions, be they psychological, medical, social, judicial, which has the risk of putting women and children at further risk. So a feminist and victim-centered approach, like the one held by specialist support services, balances the respect for women's agency and timely, effective service provision at her own pace. And we feel that pushing women and girls to engage with specific service providers at a pace that doesn't correspond to their needs after trauma can do significant harm and risk their path to stabilization. So I'll leave it there.
Thank you very much. You stressed many challenges, many important dimensions, and I think that what you said echoes the concerns raised by many women's NGOs across Europe, I would say. You highlighted the added value of the involvement of women NGO in this field, that especially with regards to the provision of assistance to women victims. Also, among other things, you stressed the challenges with regard to referrals and mandatory referrals and the lack of self-referrals, and also challenges related to the fact that the victim has to submit a complaint for her to receive adequate provision of services and assistance. As you said, a gender-neutral approach is not what is appropriate in these cases, in cases of women that are victims of violence, as Grevio has highlighted many times, and I'm talking under the control of Iris. What we need is exactly gender understanding when we're talking about provision of specialized assistance and services. So thank you very much for bringing this on board. Let's continue our discussions. We've touched upon the global, regional level. Let's come now to national level. And I would like to turn now to Eniko. Hungary is among the very few EU countries that has not ratified the Istanbul Convention. Eniko, in this context, could you please give us a brief overview and an assessment on the state response to violence against women and domestic violence? What would be your experience as a front line professionals with regards to the question on on the implementation of international and EU norms, the effective implementation of such norms at national level? Please, Eniko.
Thank you very much. First of all, thank you very much for the invitation and the discussion. I am going to look at the state response from the very ground, working for an NGO called NANE Association, which has exactly close to 30 years of experience in the field of ending violence against women and domestic violence. I believe that some of the issues and concerns I will address and I will talk about will resonate well in the situation of other countries as well. Let me start by saying that if we look at the state response to violence against women and girls, we should look at the wider framework also of promoting women's rights and gender equality, as Genoveva also pointed out to it through the CEDAW Convention. These issues are strictly interrelated, interlinked, and should be examined and assessed together. In the case of Hungary, women's rights have never been high on the agenda of any government since the democratic transition of 1989. Now, Hungary is among the countries actually that are often mentioned in the context of the backlash against women's rights and gender equality. The country is actually a good example to step back from promoting women's rights without any substantive development so far. So we often argue that we have a special backlash with no actual lashes so far. When looking at the CEDAW Convention, I must also conclude that the state response is far from the compliance with CEDAW. One of the key and basic concerns is the state's regressive approach in the field. A family-centered perspective overrides the values of women's rights and equality between women and men. And there is a lack of compliance with CEDAW in a number of policy fields, including violence against women. So there are just recurrent recommendations from the CEDAW committee without any successes, unfortunately, so far. In addressing violence against women, we should also talk about the Istanbul Convention, the specific golden standard in the field. Although Hungary signed the convention in 2014, the document became the target of attacks and fake news campaign. Again, this is similar to other countries. The current government is against the convention, and the parliament actually adopted a political declaration in 2020, in which they opposed the ratification of the convention and also to the EU's accession to the convention. I must also say that the proposal for the declaration went through the whole process in the parliament from one day to another, actually and literally, and it happened during the coronavirus lockdown. It just prevented even a potential protest against it. So currently we cannot use and cannot rely on the convention as a legally binding driver or even as a recognized point of reference from the point of stakeholders for the protection of women against violence. Again, it is the case of some other countries as well. On the EU level, as you also mentioned, we have the Victims' Rights Directive, which has, or in principle, has a relevance in the field of addressing violence against women and domestic violence. I must tell you that in 2018, a qualitative research was done by the Patent People Opposing Patriarchy Association in Hungary. It examined the application, the enforcement of the directive based on the interviews with women victims of domestic violence, but also desk research. The research concluded that victims of intimate partner violence actually have not benefited from the directive's provision in the practice. So I think it is important conclusion to bring in the discussion. When we look at the state response very briefly around the key issues, I have to say that there is a long-standing problems with the compliance with international norms and standards, and the lack of holistic and comprehensive approach for the prevention, protection, prosecution, and integrated policies are at the table. As regards to policies, Hungary does not have a national strategy to end violence against women and girls or domestic violence, not even on paper. Such violence is not included in the National Action Plan on strengthening the role of women, nor in the National Recovery and Resilience Plan that aims to mitigate the effects of coronavirus pandemic. Femicides committed in the country are the most severe signs of the failure of effective state response. Practitioners often engage in victim blaming, and the sanctions for violence are often lenient, if issued at all. The lack of systematic adequate training for professionals is also a key problem. There are substantial gaps in service provision too. For example, no specialized services for adult victims of rape and sexual violence exist at all in Hungary. An alarming problem is child custody and visitation in the context of intimate partner violence, as we have heard also today. It has led to the killing of children and also women in recent years as well in Hungary. While no specific measures guarantee to take into consideration domestic violence in custody issues, a new legislation allows joint custody even if one parent is objecting to it, which is, I think, a clear sign of violence in many of the cases. NGOs working to end violence against women are key actors in the field, as we have heard from Susanna as well, across the countries. In Hungary, the women's rights NGOs, including NANE Association, never had an influential role in the eyes of the state, I must say. Then the past decade brought a higher levels of difficulties. You see backlash without any lashes. We have been stigmatized in pro-government media as fake NGOs, as serving political or foreign interests, and also face government audit. Previous cooperation with certain institutions were ended. While women's NGOs were stigmatized or marginalized, other actors, often not with a women's rights approach or even the opposite, play important roles in the field, in policy work or service provision. An illustration, in recent debates in domestic violence, according to state actors, the opinion of women's rights NGOs supporting the victim survivors and the opinions of the fathers group and men's group nullify each other. Proposals of women's rights NGOs for the safety and protection of victims are not taken up the agenda, while other initiatives that are not useful or even harmful for victims are moving forward more easily. Just to sum up, the existing norms, the CEDAW Convention and the Victims' Rights Directive have not brought any substantive development, positive changes so far. We currently cannot count, unfortunately, with the Istanbul Convention as a legally binding change maker. We have hopes, but still it's not the case today. And one of the leading actors in the field, women's rights NGOs, are working in a hostile environment. So we have been really waiting for the EU directive as a new chance for an effective response, but I will comment further on regarding our views on the directive.
Thank you. Indeed, we will engage in discussions regarding this dimension as well. Eniko, as you said, it is important not only to emphasize success stories, but also to pinpoint to challenges, especially with regard to implementation, because one of major challenges is to put into practice what we have at the level of the legal framework, because the gaps very often between theory and practice is too wide. And having a very good legal framework, it's a good start, but it is only the start. And what is even, I would say, more important is the effective, the efficient implementation of such a framework. You mentioned also the need for a holistic approach in matters related to violence against women. And as you said, systematic in-service, initial and in-service training of all practitioners that come into direct or indirect contact with victims of violence against women is crucial in state responses. So thank you very much for bringing also the national dimension and challenges that are related to the implementation of all standards. At this point, I would like also to maybe emphasize once again the added value of the monitoring bodies that exercise this kind of control, and exactly their mandate is to check and to monitor whether any legal provisions, any legal frameworks are efficiently applied and implemented in practice. Thank you very much. And also would like to thank our attendees for already sharing their comments and questions. Please keep on, and we will come back to them in a while. So in this first round, we touched upon the important dimensions of the Istanbul Convention, on the work of the CEDAW committee, especially with regard to victims and survivors of violence against women. Then we discussed the need, the usefulness and the importance of the engagement of women NGOs and the need for gender understanding with regards to the provision of services. And also we discussed with Eniko national examples and some gaps that need to be addressed. I would suggest we continue with a second round of questions. And I will start with Iris. Eniko has just mentioned, among other things, she referred to the implementation of EU norms, to the Victims Directive, Victims' Rights Directive, but also to the forthcoming directive on violence against women. I would like to ask you, Iris, in what way you think that the EU directive will add to the standards of the Istanbul Convention? Yes.
The response is complementarity, because we see the EU directive as a complementarity to the Istanbul Convention. And an example of this complementarity is the list of computer crime offenses provided under the directive, which explicitly criminalize forms of violence that are perpetrated through digital means. But this gives me also the opportunity to point out something that is not very widely known about the Istanbul Convention, namely that it extends to many forms of violence perpetrated online or through technology, because the drafters had understood violence against women in the online sphere as a continuation of violence against women in the offline sphere. And Grevio recently offered an extensive interpretation of the provision of the Istanbul Convention to fill this with practical meaning. So, although it is not referred to in the directive, Grevio's first general recommendation on the digital dimension of violence against women explains how the Istanbul Convention provision on psychological violence, stalking, and sexual harassment can and must be applied to investigative and to prosecute these forms of violence against women that are perpetrated online. Against this backdrop, it appears that there is a range of online behavior harmful to women and girls that do not seem to come within the remit of the draft directive, but is covered by the Istanbul Convention. So, for example, cyberflashing, that is the sending of unsolicited sexual images to a victim using message apps or text, would be covered by the definition of sexual harassment of the Istanbul Convention, but would not necessarily be covered by the Article 7 of the draft directive on non-consensual sharing of intimate or manipulated material, because of the requirement to share images with other parties. Likewise, harmful online behavior perpetrated by an abusive partner against the victim would not come under the provision of a cyber harassment in the draft directive, whereas it is captured by the offense of psychological violence under the Istanbul Convention. So the directive provision on cyber harassment, in fact, requires the element of consultation with third parties and the making material available to a multitude of end users, requirements which we do not have to be met under the Istanbul Convention. As it was mentioned from you, Andriana, but also from the previous speaker, Istanbul Convention has prompted change in law and policy in Europe, and it has been 11 years now. This May, it became 11 years. So to go back to your first question, because I thought it's going to be like a short response, and then we'll go a little bit more in detail. One of the other things that makes the convention unique, it's the women's rights perspective, because the convention understands the violence against women as a gendered phenomenon, and this means that it frames it as a women's rights issue and also consider it to be the fruit of persisting inequalities and discrimination against women. And I will give you just very few short examples how this understanding runs through the convention and what it means, because research shows that domestic violence is cyclical and recurring in time. It also shows that living an abusive relationship is not a one-off event, but it is a process and a risk factor that can cause the violence to escalate. So very concretely, we have observed as Grevio throughout the monitoring that where law enforcement officers and criminal justice actors are not sufficiently trained, and they lack the understanding of the processes and dynamics of domestic violence, including the gender nature, they may not adequately assess a woman's risk and may not adequately apply the existing legal instruments available, such as the protection orders. The Convention's requirement to ensure effective and prompt investigations through a women's rights lens is essential in creating a justice system responsive to the experiences of women and girls victims of violence. And this women's rights lens, it's also visible in the requirement to ensure the provision of support services that are mindful of the many ways in which violence, such as rape, sexual harassment, stalking, impacts specifically on women, that is free of gender stereotypes and that seeks to empower women and girls. So the Convention gives a role to those specialist support services that have long been offering this type of empowering support by asking that their expertise be recognized and their funding secured so that they can continue to play an important role. These are all crucial elements to ensure an approach to the different forms of violence against women that truly corresponds to the rights and needs of the women and girls who experience such violence. And that's what makes the Convention innovative, and it is the basis on which Grevio has identified shortcomings in many countries, including EU countries, notably in the way that, for example, tendering procedures jeopardize the important work of specialist support services run by women's NGOs and associations, because they put them in competition with the private sector. One of the remarks we have, for example, for the directive. And it is on the basis of our monitoring work that I can say with conviction that any future legal instrument on violence against women in Europe and elsewhere would need to follow this approach of promoting women's rights, gender-sensitive policies, and true consideration for the persisting inequalities between women and men, gender stereotypes, prejudice, and customs that influence the responses of professionals. Convention criminalizes all the forms of violence against women and is therefore instrumental in achieving more uniform levels of criminalization across the different jurisdictions in Europe. And also it addresses the implication of gender-based violence for women migrants and asylum seekers and how to ensure their safe reception. The convention also sets up an independent monitoring body that provides tailor-made guidance to member states. And having served to Grevio for 7 years now, I can say that this type of in-depth guidance is deeply welcomed by the state parties who are engaging with our findings and are actively working to deepen their level of implementation of the Istanbul Convention.
Thank you. Thank you very much, Iris. I think that the need for women's rights perspective could be the thread of today's discussion, the need for gender-sensitive policies, as you said, and gender-sensitive implementation of standards and gender-sensitive measures could indeed be the key word of today's webinars, as you said. Gender-based violence and including intimate partner violence have very specific dynamics. It's not another offense. Victims of intimate partner violence are not another victim, let's say, but due to the special nature and dynamics of violence against women, states, national authorities and professionals need to be trained and prepared to respond appropriately and adequately to this specific situation. The specific situation needs specific responses and specialized and adapted responses. Thank you also for stressing the need for complementarity, as you said. Indeed, I think that harmonized approaches are the only approaches that will provide victims with sustainable solutions and will allow authorities to provide them sustainable solutions and sustainable responses. You, among other things, you referred to this complementarity between the Istanbul Convention and the draft EU Directive, and I could not but emphasize once again the first ever general recommendation that Grevio has issued on the digital dimension, which is, I would say, a very comprehensive recommendation, because as you said, the boundaries of online and offline violence against women are not clear. So this is a continuum of violence and need to be addressed as such. And this is exactly what Grevio tries to do throughout its monitoring procedure. So let us continue now with some other questions. I would like us, if possible, to continue with the issue of vulnerability, which is another important aspect, I think, that I would merit to be emphasized today. I would like to ask Genevieve, what is the experience and the work of the CEDAW committee with regards to the protection of women that belong to most vulnerable groups, or otherwise women in vulnerable situations? Would you like to provide us with an overview, dear Genevieve?
Thank you. Thank you very much. I think it comes as a very important question and complements all that was said until now. First of all, making the theme of gender sensitivity, the gender-specific approach against gender neutrality central for this discussion, I think it's very important. And it is connected to the issue of vulnerabilities that I will start in a minute, saying what the CEDAW committee is confirming and affirming more and more in its practice. Just to say about the gender sensitivity, is that is an issue that lack of such gender sensitivity, lack of gender sensitivity implementation, for example, of the Victims' Rights Directive at the EU. I think it's very important that, and of course, as Susanna said, it follows now in a draft directive. So it's very important to follow. Why are not states applying these gender-specific also measures existing already as women and victims of gender-based violence as a specific group in need of protection? Why hasn't that not been followed at the EU level? This is a very important question. And I think this is now that we have to enter with this draft directive and with this discussion about international and regional protection and their complementarity, indivisibility, to ask from the states now to this approach exactly as a response to the backlash forces. Otherwise, they are following the approach, the approaches of the backlash forces. Sorry, but I think I have to say that because it's important, and each and every step that will be discussed, and even further, it's marked by that. So now saying about the vulnerabilities, I think that working for women for a gender-sensitive approach, more and more it comes in the practice of the committee, but also in the realities as an issue of intersectionality. So this principle, from the point of view of CEDAW committee, has been progressively applied, and I will give just some examples of recent work that continues for the application and interpretation of this approach. First of all, women and girls that are affected by multiple forms of discrimination, almost in all cases, and in diverse political, ideological, and cultural contexts. So the committee, in addition, applies, as I said, the principle of intersectionality and adds to the consideration of the monitoring Articles 3, specific approaches, special measures, Article 4, temporary special measures where needed, Article 14, through which we monitor not only rural women, but all the different groups of women in danger in a specific country. As General Recommendation 28, very important, I think, as a basis, says that the discrimination of women based on sex and gender is always linked with other factors that affect women, such as race, ethnicity, religion, belief, health status, etc., sexual orientation, gender identity. So states must legally recognize such intersecting forms, but I think it's also now speaking at European level more and more. And intersecting forces of that compounded negative impact on women concerned and prohibit them. And continuing in General Recommendation 35, it says specifically for gender-based violence that women's experience of violence is shaped by these additional factors as race, color, religion, but also it adds HIV, AIDS status, migrant and refugee status, as it was already mentioned, age, disability. So we require from the state, and they should be required to include targeted measures for particular groups of women as appropriate. So the committee, as I said, extensively started actually identifying and exposes intersectional stereotyping of women based on these multiple grounds. Some examples, the case, for example, RPB versus the Philippines from 2014, the committee found violation of the convention and also found compound stereotyping of the minor victim of rape who was mute and with hearing disability, and recommended not only to remove the requirement that sexual assault be committed by force or violence, but also to guarantee the free and adequate assistance of interpreters for this girl, criminal procedure free from prejudices, as stereotypical notions regarding the victims. You see intersectionality, gender, age, and disability. So a recent example from case law, ON and DP versus Russian Federation, decided by the committee in the beginning of 2020. So the case concerned homophobic attack against two lesbian women in public space and lack of effective investigation by the authorities. And here, again, the committee found the negative impact of intersecting forms of discrimination on access to justice to women. Access to justice is crucial, specifically for these groups of women affected by intersectional discrimination, and failure from that to conduct an effective and timely investigation. And also, the state did not take measures corresponding to the specific nature of the crimes. They asked several times through appealing the decision of the investigating authorities that it should be qualified as hate crime. Is also something I think very much central now for this draft directive. It's important to follow on that and to specifically empower women to be able to identify when there are hate crimes against us under different grounds. So this is very important. We found it here, and we found the communication admissible because several times it was appealed, and several times the investigation authorities denied and refused actually to requalify the accusation. So more and more, I said this principle is taken into account, and to say one of the recent cases, of course, intersectionality we have also when we have ethnicity, as I said, race, isolated communities of women, rural women, but also honor-related violence, also central, I know, for the Istanbul Convention. And despite the fact that Georgia ratified and committed under the Istanbul Convention, a very sad case from just a recent session of CEDAW of honor-related violence and that kind of intersectional discrimination is the Yeranova case versus Georgia, where this woman was or induced suicide or she was killed. It's still an investigation that was pending for years, and we found violation of the state of Georgia with very concrete recommendation for very specific, this intersecting form of discrimination, which actually brought to the death of this woman. So as I said, it's more and more concrete, and I think we should require more and more from the states now. Thank you.
Thank you very much. These were some very powerful, I would say, messages. I think we can all agree with what you said, and thank you also for stressing this important case law research into help-seeking behavior of victims of violence against women and domestic violence shows that discrimination against certain groups of victims is still widespread. So it is indeed important to discuss about this kind of issues. Thank you very much for touching the important dimension of intersectionality. We touched upon the question of women in vulnerable situations. But as we know, due to their vulnerability, children also who witness violence against women suffer a direct emotional harm, a harm which impacts their development. So I would like to ask Susanna. Susanna, we know that the proposed directive includes relevant provisions on children in the context of violence against women and domestic violence. And I would like to ask you, in your opinion, what are the specific needs of children in this context, and how can the best interest of the child be ensured in the directive, please?
Just checking that I unmuted myself. Thank you. So I have to say, because it's quite difficult for me to hold back, but I have to say that when I read, in reviewing very carefully the proposal, which is quite an extensive text, but the issue of children's rights in the context of violence against women is an issue very close to my heart, and is indeed actually, I would say, in the last perhaps 3 or 4 years, has been a priority issue for the WAVE network. It is an issue that is high on the agenda of women's organizations and women's specialist services. This sort of the intersection between children's rights, safety of children, support for children's victims, child victims in the context of violence against women. So in reviewing the directive, I have to say that I had to read the paragraph. It's Article 34 for anyone that would like to look for it. Article 34 on the safety of children. There's also Article 33 on support for child victims, but it's Article 34 on the safety of children that caught my eye and that I had to read quite a few times in order to believe, if you like, my eyes. So article, and I'd like to read it because it's very short, and so it will be very quick. So Article 34 states that member states shall establish and maintain safe places which allow a safe contact between a child and a holder of parental responsibilities who is an offender or suspect of violence against women or domestic violence, to the extent that the latter, that is the offender or the suspect, has rights of access. So in our view, the proposal reaffirms perpetrators' right of access, only with this term that is used in this article, without due consideration of the failure and the failure that has been well documented by Grevio, which I will get to as well, but by women's organizations, the failure of civil and criminal justice systems to address the fundamental right of the child and mother to live free from violence, and how custody and visitation exposes both the mother and the child to serious harm. And the discussion around the best interests of the child is a discussion that we're also having here in Cyprus, because there is a reform. If I may bring in sort of a little bit of my own national context. This term, best interest of the child, is a term that is thrown around quite easily, and excuse me, without anybody actually defining what this means, both in law but also in practice. And in the context of violence against women, there is a complete absence of an understanding that the best interest of the child is directly related to the best interests of women. Of women victims. And we understand mothers to be the most important protective factor in a child's life. So in the custody, so I think it falls so far from the standards of the Istanbul Convention, which is reiterated in Article 31 on custody, visitation rights and safety, which aims to ensure that judicial authorities do not issue contact orders without considering incidents of violence, right, covered by the scope of the convention. The explanatory report to the convention further emphasizes that it's indeed a complex issue to guarantee rights and safety of victims and witnesses while considering the parental rights of the perpetrator, particularly in cases of domestic violence, where complying with contact orders can present a serious safety risk for the children, but also the mother. And for us, this safety risk is interlinked. And the EU Directive, it really falls short of this standard. We really believe that this is an issue that because we understand that the European Commission now, their job is done. Yes, and now the responsibility lies with the European Parliament, and as women's organizations and as the WAVE Network, we will be advocating very intensely with the European Parliament to ensure that this article is extensively revised, and that they take into account the findings of the midterm horizontal review of Grevio on the implementation of Article 31 to the Istanbul Convention. Just to tell the audience that the horizontal review is a document that covers the findings from 17 countries that were evaluated or assessed, if you like, by the Grevio committee, which identified gaps and challenges in protecting children and their mothers from domestic violence. Just to name a few, they cited a lack of understanding of professionals about the harm children experience as indirect and direct victims of violence, the non-recognition of violence, which leads to secondary victimization of both survivors in legal proceedings, and also something that we understand is not mentioned in the directive, but this is an issue that we are grappling with in many member states, is the use of the so-called parental alienation syndrome, also known as parental alienation, which generally refers to the presumption that a child's fear or rejection of one parent stems from the malevolent influence, if you like, the mother in the case of domestic violence. This is an issue that we are grappling with. Parental alienation syndrome, even though it has been rejected in the scientific community, continues, at least in practice, if not in law, to be used in judicial proceedings regarding child custody in the context of domestic violence. And this is something that we're extremely concerned about. And we would actually consider advocating the European Parliament, who have also issued in their report in October 2021 on child custody and violence against women, we would advocate that this is expressly forbidden in judicial proceedings in the directive. Of course, we understand that there is issues of competence, of EU competence, and we understand that many of the shortcomings of the EU directive stems from the perceived, if you like, because we don't always agree with what they consider their competence or not, but their perceived lack of competence in many areas, and that might also explain some of the limitations and the limited scope, if you like, of the directive. But this is something that we're extremely concerned about, and will be making a lot of noise.
Thank you very much for your intervention. It is true that custody related matters and visiting rights are are close to the heart of Grevio, I would say. I mean, as you said, Grevio has again and again identified many challenges with regard in the implementation of Article 31, many challenges in practice. And again, this issue of gender understanding from professionals that work in the civil and criminal justice systems, it is another challenge, as you said. We do understand some perceived limitations with regards to the competence, but at the same time, I would like to say that here we could see an added value with regards to a non-regression clause. A non-regression clause that will refer also to other international standards in the field of combating violence against women, which is something that I would like personally to see also in the EU directive, a non-regression clause that will refer expressly to the key international and regional instruments and conventions in the field. So in this context of complementarity and harmonized approach, I think that this would be also important and useful. Thank you very much, Susanna. We touched upon a very important and sensitive, I would say, topic. Having addressed this specific topic, I would like us now to look at the draft EU directive now as a whole. Susanna, you kindly pinpointed some challenges, some fields where improvement can be made. I would like to ask Eniko now, what has been so far your assessment with regards to the EU, the draft as a whole? Based on your experiences, do you see, Eniko, any other fields, any other issues that need to be addressed, that any provisions that would raise concerns or questions apart from those that Susanna mentioned? Please, Eniko.
Thank you very much. First of all, I must say and start with that finally, it's a good sign that we are discussing a specific and dedicated EU legislation in the field of ending violence against women and domestic violence. I think it should be celebrated. It sends a strong message actually about the seriousness of the problem, about the huge differences, but also failures in the national responses, and about the commitment and political will at the EU level to take targeted actions. And I'm also convinced that for the countries where the Istanbul Convention is rejected, so we cannot apply the complementarity in this sense, there has been and there are even more expectations and hopes towards the directive and the final version of the directive, I must say. At the same time, I'm also sharing with you some of the key questions and concerns that have been raised by reading the text of the directives. First of all, my first question and also concerns are around its scope and its comprehensiveness. So this is, I think, the basic concerns I would like to share with you. Of course, in addition to the women's rights, the lack of women's rights lens or the question of women's rights lens, both all of you have mentioned already. I mean the comprehensiveness in a sense of both addressing all forms of violence against women and domestic violence in a holistic way, and also applying the 4 Ps approach as the Istanbul Convention is doing the same. So the provision on the scope of the directive says that it shall apply to the following criminal offenses. I'm saying quote by quote, offenses that are regulated in the directive. Those are actually the rape, female genital mutilation, and cyber-related crimes. Secondly, acts of violence against women and domestic violence that are already criminalized in EU law. And thirdly, acts of violence against women and domestic violence that are criminalized by the national law. So as for the 2 first items and elements, the existing EU legislation and the draft directive, actually they are limited to certain acts and certain offenses. And when we look at the third one, on what is criminalized in national law, there are again huge differences across countries. So for example, in the case of Hungary, violence against women as such is not included in the criminal legislation or in any other legislation. The criminal offense of domestic violence, for example, leaves out certain groups of victims and certain acts of violence. So in this context, I have concerns about the real scope and coverage of the directive. I'm afraid actually that it will provide a narrow, limited, and fragmented response with its strong focus on the criminal field, but even within this only around certain crimes and offenses. It is also important to underline that there are numerous factors that hinder women in seeking and accessing justice. They either do not want to or cannot engage with the criminal justice system, as Susanna also pointed out in her contribution. It might also shrink the scope of the directives if we stick to this criminal approach. The concerns about the narrow scope were also raised by the WAVE network, as Susanna pointed out, in its submission to the public consultation on the draft directive. There are also other questions and concerns when we look at the comprehensiveness regarding the 4 Ps approach. While there is a strong focus on the criminal aspects, there are elements in the prosecution and punishment pillar that are actually missing from the draft directive. For example, it does not contain the prohibition of alternative dispute resolution, mediation, and other similar methods and processes in cases of violence against women and domestic violence. According to our experience, mediation and such other methods mitigate the accountability of perpetrators actually. These also lead to secondary and repeat victimization, intimidation, and blaming of the victims, as the practice shows. I just recall a talkative example when a woman victim of domestic violence explained that she has been sentenced to mediation with the perpetrator. I think it sends a strong message that she felt it like a punishment. The Victims' Rights Directive says in general that the restorative justice services, including, for example, victim offender mediation, family group conferencing, and sentencing circles can be of great benefit to the victim. At the same time, for the cases of violence against women and domestic violence, The Istanbul Convention addresses the prohibition of alternative dispute resolution. Although the draft directive recalls the Istanbul Convention as a guiding source and principles, it failed to address this issue and to include the prohibition of such dispute resolution methods, including mediation. The other key missing issue I would like to address is the protection and safety of children in the context of custody and visitation decisions and procedures. So I do agree and do share with the concerns Susanna has just shared with us. This issue requires urgent action in itself, but I must say also that it is one of the thematic fields of the backlash in several countries, not by accident. The draft directive contains provision on providing safe places for the child visit. With the offender, it, however, fails to provide reference on how the rights and safety of the child and the non-battering parent, the mother, shall be guaranteed even before regarding custody and visitation proceedings and decisions. This question is clearly regulated in the Istanbul Convention, as some of you already mentioned. Also, importantly, the European Parliament adopted a resolution on the impact on intimate partner violence and custody rights on women and children. So the lack of specific reference to this issue in the draft directive is a clear shortcoming and poses a clear danger, I think, if it remained as it is now. There are several other concerns and questions, but I have only highlighted some of the key ones coming from the national practical experiences. Maybe one more thought, if the time allows. The directive is referring to some important tools and means, such as protocols, guidelines, codes of conduct, minimum standards. At the same time, I do think that their added value and their effectiveness will highly depend on their foundation and approach. Whether the content is really based on the international standards, as we are talking about now, like the CEDAW Convention and the Istanbul Convention, first of all, the zero tolerance principle, the specificity of violence, addressing the root causes of violence, and whether these tools are based on and reflect the rights and needs of victim survivors and their reality. The question here is, will we have the same understanding on tackling harmful gender stereotypes, trauma-sensitive, gender-sensitive, and child-sensitive approach? Will we have the same understanding on the best interest of the child, as Susanna also pointed out? If such a right-based and needs-based approach is not guaranteed, that will be an obstacle for an effective response, I believe.
Thank you. Thank you very much, Eniko. It's extremely useful to have this national input, let's say, experience, and thank you very much. I would like to echo what you said, that this draft EU directive is certainly and undoubtedly a very positive step, of course, especially for states, for countries that have not ratified, for example, the Istanbul Convention. So yes, I think we can all agree to this, that this is indeed a very positive step, and it is I think also important that we discuss it, because it is at the level of a draft right now, so it is good to provide some food for thought for possible amendments to ameliorate the impact of the directive. You referred to the scope and the comprehensiveness of the draft EU directive as it stands right now. Of course, the issue of the involvement of women's NGOs and the very sensitive issue of custody and visiting rights. With regard to the last element, I would like to pinpoint, to emphasize actually that as Grevia is concerned, children that who witness violence against women or domestic violence are considered victims, not just witnesses, but victims, and they should must benefit from targeted protection measures. And as you said, the violence against their mother should be considered as a factor when determining the best interest of the child. So this is crucial. Thank you very much, Eniko. So I think we could continue with the third round of questions. I would like to turn now to Iris. Iris, could you please let us know your views on how the Istanbul Convention and the CEDAW Convention interact among them?
Thank you, Andriana, for the question. The CEDAW Convention is, of course, the much more senior women's rights treaty between the two. The Istanbul Convention took inspiration from the CEDAW's monitoring, more specifically its interpretation of violence against women being a form of discrimination against women. And this understanding of violence against women runs through the convention and makes it such a strong tool. So following the entry into force of the Istanbul Convention, CEDAW updated its general recommendation number 35, which, if I may say, in part seems to have taken inspiration from the very detailed set of measures of the Istanbul Convention. And also CEDAW calls on all European states that it reviews to ratify the Istanbul Convention in its concluding comments as a measure to improve women's protection from violence. And in the same way, Grevio looks at CEDAW's concluding observation for its country-specific assessment of the implementation of the Istanbul Convention. These are just some examples of interaction, and another one would be the fact that both Grevio and the CEDAW committee are members of the platform of independent experts mechanism on ending discrimination and violence against women. This platform, which I currently preside over, allows all 7 independent expert groups around the world to come together and exchange on common areas of concern.
Thank you very much, Iris, and thank you for mentioning the platform, the Violence Against Women platform, which is an important forum, let's say, for exchanges, and it is a way of enhancing cross-fertilization. You refer to the interaction between the Istanbul Convention and the CEDAW Convention, and this nice overview allow me to go a step further and to turn now to Genevieve for a more specific issue. And that is the issue of compensation and reparation for women that are victims. This is another area, I would say, where the monitoring bodies and, of course, the CEDAW committee call states to put in place measures. I would like to ask you, Genevieve, what is the work of the CEDAW committee in this respect with regard to compensation and reparation for women victims of violence?
Thank you. Thank you very much again. I think it's an important element also of the discussion around the draft directive, which actually aims also one of the elements of improving specifically the implementation of the state obligations and due diligence obligations from that point of view. So I will comment also on that. But concerning the work of the CEDAW committee, of course, monitoring the obligations of the state, also the committee monitors and recommends to the states, also systematically, as I said, that victims are protected against re-victimization and have access to effective reparations, including compensation, have access to appropriate redress, always including compensation and reparation. I think this issue has been extensively developed in the recommendations. And in addition, when there are laws, and because something that I will mention also in the European context further, that laws in countries providing for financial compensation by the state for example, there are recommendations for allocating sufficient resources for provision of financial compensation to victims of domestic violence and victims of other crimes of gender-based violence against women in countries also. Recommendations to countries in the region, some of them already part of the Istanbul Convention. So we look at this issue very much. And also, I would like to say there is a specific case, VPP versus Bulgaria, where the committee dealt with the issue of lack of remedy for finding allocated compensation to a minor victim, girl victim of sexual assault. So in this case specifically, there were no domestic remedies available to execute successfully the decision for financial compensation for moral damages. So it made it impossible for the girl to find justice in Bulgaria. So the committee found the communication admissible and recommended specifically for domestic remedies to provide compensation, reparation, and address here, I would like to say, the health and rehabilitation and other needs of VPP, very important, and also to ensure that she has access to adequate compensation for the pain suffered, but also to legal aid, specifically legal aid for actually allocation of compensation, and specifically assistance was recommended for the states of Bulgaria for moral damages, also from state funds and from the state. I would like to say that it has not yet fully implemented these recommendations, general recommendations, because the views of the committee have an individual part, turn to the individual, and I will say there also the committee can find the need to recommend adequate compensation reparation for the victim, but for the women's rights, for the rights to equality infringed through this act found as a violation under the convention. So this is in the individual part, and these measures recommended, very often we found that there is follow-up on the states at least pay, not in all cases commensurate compensation, but also they also apply other measures of reparation to the situation of the specific victim. And I can say that you all know there is one case, in the case González Carreño, it was related with versus Spain, related with the death of the child during visitation, where not effective measures were taken exactly concerning, allowing the violent father visitation rights, which was really against all the situations and the facts during this case. So this mother, Mrs. González Carreño, not only had she the views of the committee on failure of the state of Spain to protect her and her daughter, but also she had the highest amount of compensation after a decision of views of the committee, 500,000 euros. You know, it's really a precedent, and Spain recognized also that the optional protocol is obligatory in terms of indicating that compensation should be paid. So it's very important. In other cases also it was paid by different countries when there are decisions for violations of the CEDAW convention. In the case of VPP, as I said, the individual compensation, some individual compensation was paid ad hoc, but the general measures for, which is important now under discussion, for effective compensation and reparation were not implemented yet in Bulgaria. And here I come to because the European standards allow so. That's what I want to say. For example, the European standards, specifically the Directive 2004/80, which regulates this issue for the financial compensation by the state, is such a minimum standard. I don't know what your view is, that if there is just a system or a law called for financial compensation by the state and other measures for the victims of crime, it is enough. It does not question at any moment threshold, or as in some recommendations of the committee, we can find allocate sufficient resources, insufficient resources. Here is the minimum standard is really minimum. Now, built on that, we have the provisions for compensation in the Victims Directive 2012-29, which are a little bit broader, let's say, but it also does not come to the idea of full compensation reparation of the victims. But it's important that this directive speaks, even if it's not completely used, speaks about vulnerable that vulnerable victims in need of specific protection, those victims of gender-based violence. Now, concerning this draft directive, I think that there is some extension also speaking because it will address re-victimization more, but also the reparation, because victims, they say, would have the right to claim full compensation from offenders for damages, including the cost of healthcare, support services, lost income, physical and psychological harm. But I would like to ask how to ensure within all these instruments and the developing now and the refining of this draft directive to have for the victims full compensation, and if, for example, the perpetrator cannot pay for any reason because of transfer of assets, and as we know that it is done currently and everywhere, so how will the state actually provide for compensation for these victims, minor victims especially, if the situation is the same? And our research with several countries, Hungary included, under a European project, actually found that we found that it's really this right is not used by women. They are not supported enough by adequate and specific legal aid. So they are discouraged. They are not seeking immediately compensation, and they're often stigmatized and accused of seeking compensation, but they don't do that. The research shows that they do not do that, and they don't have specialized, as I said, legal aid. So I think it's very important how we'll go further also in this field and require more based on this directives, financial compensation by the state, and also victims directive and this new directive. But how, as my colleague said, this fragmented, basis, how we'll put it in one tissue, let's say, of provisions, at least what we can do within this draft directive to make this access to justice, because finally this is access to justice, because there is no justice until there is really compensation for the victims. Thank you.
Indeed, thank you very much also for making this connection and this comparison with the EU standards. As you said, a monetary compensation, financial compensation, while helpful, it's not sufficient as such. It is just, I would say, the first step for reparation, because the term of reparation, as far as I can see it, is much broader than the term of compensation, and it must include rehabilitation, building resilience, and even empowerment of women victims. It should include the elimination of all kinds of consequences of the illegal act of the violence that the women suffered, and no, it should not have only a financial dimension, but must be something more than this. From the Council of Europe standpoint and the Istanbul Convention, the relevant provision is Article 30 that deals with the compensation that for any kind of damages suffered as a result of the offenses covered by this instrument. And Article 30 covers compensation that should be given primarily from the perpetrator, but also by state authorities. And thank you also, Genoveva, because you, among other things, you stressed the lack, first of all, of information about the rights to compensation, but also obstacles to access the courts, to access courts, and obstacles to legal aid that would help victims to claim compensations and address in this way the consequences of the violence. So thank you. We dealt with the issue of compensation and reparation that is that concerns the consequences, let's say, of violence against women. An equally important issue is that of prevention. And I'm turning now to Susanna. Prevention is a key component of efforts to combat violence against women and domestic violence. And I would like to ask you, Susanna, what do you think that are the most important prevention measures that should be included in the EU directive, please?
Yeah, thank you very much for the question. You know, often the discussion around prevention is one that is overlooked, if you like, or there is often a very narrow perspective of prevention measures, and this is one of our main concerns, and I mentioned it in my first intervention. Our main concerns around the proposal for the directive is the strong law enforcement focus and the criminal approach to ending gender-based violence against women and girls, without precisely focusing on prevention measures that will mitigate, if you like, the complex situations leading to gender-based violence against women and girls in the first place. Research has shown that prison, if you like, does not make violent perpetrators less violent. Right? Criminalization, according to some studies, has not shown a significant impact on reoffending rates. So although national laws on violence against women and girls have been in place for several decades, they have not had any impact on victimization rates. So the EU directive will fall short of its goal if it doesn't put prevention at its center. This is our view, along the three-pronged approach, which includes primary prevention, meaning to reduce vulnerability before violence occurs so that it won't occur. And this can include measures also foreseen in the Istanbul Convention in relation to education. I was just thinking in Greek and then I had to translate for some reason, but also to the media. Yes, so, but mainly in education, in order to reduce vulnerability before it occurs. And also not only education, but we feel very strongly, if we understand violence against women as a cause and consequence of gender inequality and inequality between women and men, then our main focus is to have an integrated approach as foreseen in the Istanbul Convention, which foresees the integration of measures to promote equality between women and men and gender equality with measures to combat violence against women. So we also think we should include having in mind a comprehensive approach to prevention, secondary prevention, which is identifying violence and intervening to disrupt it as early as possible. So early identification measures, emergency support, risk assessment, all these different types of measures that will prevent repeated perpetration, re-victimization, fatality, femicides, but also tertiary prevention, which is one of the areas that is least paid attention to, which is that long-term intervention and support that survivors need, survivors and their children need, in order to reduce the negative impact of violence and to prevent reoffending. So both with perpetrators, but also with victims, to lift them out of those circumstances that made them vulnerable in the first place. So these three approaches complement each other, and only together are they able to truly combat violence prevent violence against women and girls. And in the current draft of the directive, prevention is treated as a sort of add-on, as an afterthought following criminalization. And it is not at the center of policy as in our view it should be. We believe that prevention should be evidence-based, should apply an ecological human rights approach over the life course, and be grounded, as I said before, in gender equality. And the directive, I mean, it's as Andriana has said over and over again, I think the common theme during this webinar and in our discussion is this women's rights approach, which needs to be the common thread across all legal instruments, which we feel very strongly the Istanbul Convention has, obviously the CEDAW Convention as the Bill of Rights for women, but which this directive is lacking. And this prevents, if you like, this integrated approach or this complementarity that Iris was talking about. So yes, I'll end it there. But just to very briefly, it needs to have a very, in our view, a very broad approach to prevention, which includes measures in education and resources and policies to promote gender equality. And this is missing, this sort of integration between gender equality and violence against women and domestic violence is missing from the directive. And I think that would make it stronger, but also secondary prevention and tertiary prevention, which is completely missing.
Thank you very much, Susanna. As you said, education, training, and treatment programs are very important ways to prevent violence against women, primary prevention, secondary prevention, but this pillar is extremely important, and there should be a focus also in preventing violence against women. Thank you very much. May I continue with Eniko and our last question before we address any questions coming from the attendees? So, Eniko, we have discussed many positive steps taken, positive elements contained in the draft directive, but also some areas where which could be improved. In your opinion, I would like to ask you what would be the priorities and the key steps for improving the response to violence against women, in light, of course, of the draft directive, but also beyond that. Could you please give us an overview of some key priorities and steps to improve the situation?
Yes, thank you. First of all, I would say that it is important to keep the ratification and due implementation of the Istanbul Convention high on the agenda, both at national and EU level. I believe that we need a strong and comprehensive basis, a tool like the Istanbul Convention, that we could complement later with the EU legislation. So this is my very first message, just to keep the ratification and implementation of the Istanbul Convention high on the agenda in different levels. Regarding the directive, from the ground, we would like to see a strong and clear content that holistically respond to violence against women and domestic violence with a women's rights approach, as it was said several times before. As for the scope, the text shall be as comprehensive as possible. It would be important to extend the scope beyond the criminal field in general. Furthermore, also speaking from the experience, if there is a big room for flexibility at the interpretation of certain measures and provisions, and the discretion regarding their application, the response really will be dependent on the will, political will or other will or commitment of the state or different authorities and institutions. The text, as it is now, provides only the minimum rules, but it shall really go up to the maximum of the minimum, I would say. I also think that the directives shall reflect clearly to the problems and issues in the fields that are widely present now, and or are emerging as well, such as the prohibition of alternative dispute resolution, mediation, and the protection of women and children in the context of custody and visitation. A strong legislation, as we said already, would be valuable for all countries, but would have special importance in those where the Istanbul Convention is under attack. It is of most importance that the proposed measures and tools introduced follow the international norms and standards and thus place the human rights and safety of the victims in the center. A related rights-based quality check and assurance, as well as the accurate monitoring and evaluation and impact assessment mechanisms for the implementation would strengthen the effectiveness of the responses, I believe, both for the directive, but also beyond that. Also beyond the scope of the directive, the providing adequate funding in the field is really a crucial issue we haven't touched upon yet. But it is also important to follow up on where the money goes and what it is being spent on. Measures and programs with EU funding shall also be based on the international norms and standards, placing again the rights and safety of the victims of the center of all the measures or the programs or the projects. The introduction of the rights-based quality assurance, again, monitoring and evaluation for the distribution and utilization of EU funding would be also meaningful and important. Last but not least, I stress the need and importance of the real substantive involvement of women's rights NGOs working in the field, including women's specialist services in legal and policy processes, such as to the further stages of the legislative process of drafting and finalizing the directive. Their crucial role in the implementation shall also be guaranteed later on. These organizations are in a day-to-day contact with the victims, survivors, therefore they can channel their reality, experiences, and needs. They see the structural, constant, and also emerging problems that require action. The decision makers, stakeholders, shall utilize the expertise and experience of these organizations, both at national, EU, and also global level. Their involvement would certainly improve the quality, effectiveness, and efficiency of the response from the EU and also beyond. I thank you very much.
Thank you very much, Eniko. I think this was a great way to complete this round of questions. As you said, political commitment and commitment of all decision makers at national, regional, and international level is the key to responses to violence against women. We have a few more minutes before we conclude this webinar, and we have a question that I would like to address to all of you. Iris has already kindly shared her thoughts in the chat. So Kyriaki Haralabous says that states are still struggling to implement the CEDAW and the Istanbul Conventions, and little effort had been put on effective systemic changes. Now we are discussing about one more instrument, an EU directive on the same matter. So does the fragmentation, asks Kyriaki, of the obligation of states in the several instruments entail any risk? How can we be prepared to respond to such risks? Please, dear panelists, dear ladies, do not feel free to take the floor should you would like to address this. Who would like to start? I could start. Yes, please, Iris.
No, I think that I gave quite a quick response to that. honestly, I don't see a risk actually on that, on having a EU directive, despite of the things that we see that are missing in the EU directive, and that have been very clearly pointed out here. I would just wanted to mention once more that that's why I see that the Istanbul Convention remains the legal instrument in this field. But with CEDAW and the EU directive, it's just a complementary. So that's why I don't see a risk in the on having several instruments in this. And as I mentioned before, the EU directive, it is missing this part, for example, that the Istanbul Convention, it has, that it's criminalizing the digital forms of violence. And also we are looking for some changes on the tendering procedures, for example, because as it is mentioned in the EU directive, because Grevio has identified shortcomings in many countries, especially including the EU countries, notably in the way that tendering procedures jeopardize the important work of especially support services that are run from women NGOs and different associations, because they put them in the competition with the private sector, and we don't see that as a useful tool in the directive. But this is just a draft, and as far as I have understood, it is open for discussion. I participated in several discussions. You, Andriana, have participated in several ones, and many networks like WAVE and many women respected NGOs and associations already have mentioned the things and the problems that they actually face with the draft. So we just remain with the hope that this is just a draft and is going to reflect all this concern. But bottom line is that we don't see a risk with several instruments. It's the opposite. We see them as a complementarity to each other.
Yes, thank you. Susanna, please.
Yeah, I read as soon as she posted it, Kyriaki's question, and I completely understand her concern regarding fragmentation. It's something that we have also as women's NGOs. These are we see fragmentation in policy implementation, in institutional mechanisms on a national level. So I completely understand this concern. I think I agree with what Iris has said regarding complementarity. And I think that if we just take, for example, the two instruments that have been ratified, if you like, in Cyprus, for example, in other countries, we see, because there is such a strong link. It's, as you also mentioned, Andriani, before, that there's something missing, right, from the proposal as it stands now, and this is why precisely why we're here, is because we will be working towards improving this text, precisely to ensure that there is this complementarity, because CEDAW and the Istanbul Convention are extremely complementary. One strengthens the other, they build on one another. And this, coming from an NGO perspective, these two instruments are extremely useful tools for us as women's rights activists and as civil society organizations, in order to hold states accountable in their efforts or not, to prevent and combat violence against women and girls. So I think that, again, going back to perhaps, as we call this common thread, I think that with the clause, and if you could say a few more words about it, Andriani, that would be great. This clause that you were recommending that there is, but also to ensure that at least on the level of main principles that they need to strengthen these synergies with other legal instruments, and particularly in relation to ensuring this women's rights perspective. And I think in doing so, even if the scope of the directive may be more limited due to issues with EU competence, it can work in a complementary way and precisely strengthen our efforts to implement the Istanbul Conventions in those countries that have ratified.
Thank you very much, Susanna. Before I take the floor, I don't know if other panelists would like. Yes, Genoveva, please.
Thank you very much. And I agree with my colleagues completely, with both of them, and that it's not a problem. It's the fragmentation. It comes as the commitments of the states and actually giving up their sovereignty in this field actually comes, which is important. So we have to follow and monitor them, from treaty bodies, but also from the other institutions and bodies, but also from the civil society. It gives more opportunities. And I think it's important to refine these standards, to implement them, to follow the implementation, to watch it and use all the mechanisms available, because knowing about the backlash is very difficult. They engaged already and we have to fully follow this engagement. But also very important issue, I think, is that in all the conventions and all the instruments, also in the EU, there is this mutual, because they came together, the states, with under these conventions, these agreements. So they have to respect them, but also they have to watch each other if they respect it. We forget that it's not up to just civil society and others. It's first, as you know, among themselves that they have to follow that, and we have to push them to their responsibility and monitor the responsibility of others with whom they came together. It's something that we forget about the Istanbul Convention, about the other convention. It's everywhere there, but they don't use it with each other and against each other, and they should. And this is another way we have to monitor. If they respect human rights, women's rights, they have to follow also how their colleagues there on this agreement, they respect it. And also a question, because it came also from what Susanna said, is it about the EU competency, having more gender approach? Let's focus on that, because it's one of the really thematic elements that came out of all the problems and elements that we analyzed and together and individually in our exposés. So I think, is it a question of limitation? I don't think. I think they have the mandate to have gender sensitive approach, and we have to push for that. Thank you.
Thank you, Genoveva, for this very strong message. In the meantime, I'm reading your messages in the chat, and we are grateful. And many thanks also to you, Anna Vujuka, and also greetings to Robert from Estonia. Among other things, Robert stresses the fact that in its careful wording, the EU draft directive seems to downplay the importance of gender-sensitive approach and to refuse to effectively tackle the gender-neutral approach. I kindly ask you also to consult the chat. Thank you also, Maria Elisa. She has from Spain. She has a question. She asks what measures should be taken so that the regulations that protect the victims should be shielded and not to be exposed to the ups and downs of politics and different governments, to make sure that progress made cannot be reduced. And do you consider that the current guarantees are sufficient? Coming back, just reading that in case the panelists would wish to address this. In the meantime, I would like to say that It is true that states can be bound by various instruments and standards, but at the end of the day, they must respect the obligations arising from standards that provide higher level of protection. So coming back to the issue of the non-regression clause, yes, it is the provision 49 of the draft EU directive. Me personally, I would like to see a stronger wording, emphasizing the needs for states to apply higher standards that are binding for these states. So this would be a good example of this harmonized approach and complementarity. Dear panelists, if you would like to respond to any questions in the chat, let me see also. Many greetings to Ms. Kostopoulou. Thank you very much. She says that complementarity will exist only where the directive will be more detailed on crucial matters and or go further than Istanbul Convention and CEDAW. So with regards to Maria Elisa's questions about how to guarantee that we don't go step backs with regard to the level of protections based on politics or changes in governments, I don't know if you would like to take this question from my side. I would like to say that as long as states have ratified international instruments and are abide by them, I would see that there would be a stability in this. All the more so that they are monitored by independent bodies, and this is reassuring. Any last comments, I don't know, from you, dear panelists, or Susanna, before we conclude our exciting, I would say, discussion, please?
Yes, I'm also looking at the time, and but it's a discussion that really I think there should be one of many other webinars, maybe where perhaps we could look into specific issues. But I just very quickly, before I thank everybody, it's been an honor for me to be on the same panel as Genoveva and Eniko and Iris, and with you, Andriani, and so thank you so much. But just to comment, not very helpful comment, I think, that I will give to Maria Elisa is that I mean, this is something we grapple with all the time, how to ensure that there are those mechanisms in place to ensure that policies that are implemented in order to comply with either the Istanbul Convention or CEDAW are sustainable. And we have seen, you know, in my 18 years, whether it's on a national level, on an EU level, we've seen that, you know, even with the change of people, right, in certain posts, whether it's at the European Commission or on the level of national governments, how quickly things can change and how priorities can change based on changes in whether it's ministers or government parties and so on. So I think that, you know, the answer, there is no real answer, but I think that it's about due diligence, and it's about having a strong civil society, you know, even with all the limitations and the restrictions that we may have in many countries, is to hold states accountable. And to use all avenues. And I think Genoveva also, I think it was before the webinar started, about the optional protocol to CEDAW, you know, to take advantage of our opportunity to engage with the CEDAW committee, to engage with with Brevio, and I think, you know, this is what our role is to hold our governments and our states accountable in compliance, in relation to the compliance to these legal instruments, and I think that that's where really what our role is, and I think it's very important.
Thank you very much. Unless our dear panelists would like to add something, I would like to warmly thank you, all of you, for your input, for your powerful talks and ideas, and for sharing your concerns. And I think this was very it was for me an exciting discussion, and there are many key messages that came out of this that we will take them back, and maybe I'm looking at Susanna, we could do something with all these key messages. Yeah, and so I would like to warmly thank you for your participation. Many thanks to the attendees as well. I think we can close this webinar, and we could see whether there could be some follow-up webinars on more specific focused issues. Thank you very much. Bye-bye.
Thanks.
Thank you. Bye.
Thank you, Andriani.